looks like it's being streamed live now. Yes, it is. Perfect. And before I start hearing my own voice while it's being streamed, I'm just going to mute it there. Okay, sorry about the delay. And thank you everyone for joining us tonight. Before we start with the presentation, I'm just going to go over some of the NAMI Santa Clara County updates. So good evening and thank you for joining. I'm Ravina Nimbalkar. I'm the Executive Director here at NAMI Santa Clara County, and just going to go over some updates. Our helpline is up and running from 10 a.m. to 6 p.m. by phone as well as email. And we do have, you can walk into our office between 10 a.m. and 2 p.m. And we do have after our family support, which is available on evenings as well as weekends. All our support groups are listed on our website. Our website is namisantaclara.org and offered either over Zoom, or we have some in person, some are hybrid as well. For educational classes, such as family to family, familiar to familiar, persona to persona, peer to peer, provider education, you can contact the helpline number 408-453-0400 and select option 1 for further details. And if you're interested, you can put your name on the interest list. I think all our programs are going to be now in the new year, the new programs. NAMI Basics is on demand and on our website, and you can take it at your own pace, and so is NAMI Homefront. The next FaithNet MH101 is going to be on November 21st at 11:30 a.m. And you can call our helpline number if you would need more information about it. Our community peer program continues to match by hospitals as well as self-referrals. And if you're interested, we have a lot of information about our community peer program on our website, namisantaclara.org. NAMI Walk Silicon Valley took place on October 5th. And for those of you who joined us that day, thank you so much for all your support and coming in. Thank you for volunteering. Thank you for raising funds. All I want to say is that we are still not at our goal yet, but we still have time until December 5th to be able to raise funds. So if you are still raising funds, thank you so much. If you are getting close to earning a recognition reward, we have some amazing NAMI swag. You can still do it until December 5th. And if you're not aware of what the recognition rewards are, it's on our NAMI Walks website, which is NAMIWalks.com/Silicon Valley. So that we're able to meet our goal for the walk, we have launched the auction, which is live. Many of you would have already received the email about the auction, but if you need more information, do let us know and we can share that as well. We have some really nice, amazing things on the auction, so do check it out. The deadline for bidding on the auction is until December 3rd. NAMI is again this year going to be participating in the Giving Tuesday. And NAMI has been providing critical mental health services for the last 49 years. Next year is our 50th anniversary. And so keep an eye out for our Giving Tuesday campaign. Giving Tuesday this year is going to be on December 3rd. You'll get to know more about. We're going to share some amazing story and you'll know about what we've done in this year, what we've achieved. NAMI is also participating in the holiday drive. Each year, NAMI Santa Clara County distributes gifts to patients in hospitals, mental health resident facilities, and homeless shelters, as well as participants at self-help and veteran centers. And every year we distribute over 700 gifts. And this year we are giving some gift cards and some fuzzy socks and some candy. And we are not accepting the gifts, but any donation would be really helpful. So thank you in advance if you've already donated to us. Okay, so let's move to our presentation. So tonight, Egle Neverich, I hope I pronounced your name correctly, will be discussing the Santa Clara County Community Assistance Recovery and Empowerment, this CARE Act, which is implementing soon. And the CARE Act is a new civil court process to access existing community-based service for those with untreated schizophrenia and other psychotic disorders. Egle is a PhD LCSW, is a member of the Behavioral Health Services Department Management Team overseeing CARE Act implementation in the County of Santa Clara. Egle has been with the County of Behavioral Health for over 11 years in various clinical and administrative roles, including addiction, medicine, primary care, intensive outpatient services, and housing supports, and most recently launched the AOT. In her personal life, Egle is a caregiver of a family member with a developmental disability, which informs her approach to developing client and family-centered program. And now I'm going to hand it over to Egle. I do want to let all of you know that we are live streaming. This presentation, so you can even watch it later on our YouTube channel. And when you have questions, please put the questions in the Q&A section. And then if you don't want to chat or make any comments, but you can put it in the chat section. So over to you.
Thank you so much for this introduction, Rovina, and for being so brave and trying to pronounce my name. That's the first test for everybody. So as Rovina said, I'm Egle Nerovich with the County Behavioral Health Services Department, and please bear with me while I go really quickly through the screen sharing exercise here. And we'll get the presentation onto the correct screen. So today, it's going to take about half an hour of me presenting, and then we will open it up to questions. If there is a question that is important to address while I am presenting, Rovina can always stop me and ask me to answer it. We're talking about Community Assistance, Recovery, and Empowerment Act, CARE Act for short. And we will focus on how we are approaching the implementation in Santa Clara County. Even though this is a state legislature that created this act, every county has somewhat of a discretion on how they choose to implement it. So just a little bit of general information about CARE Act for those of you who may need a reminder or a refresher about it. It's a new civil court process. And we're saying new civil court process because we already have one civil court process for behavioral health services, and that's AOT, or Assisted Outpatient Treatment. So this is another one, very similar type of process where nobody is being taken to a criminal court, nobody has done anything wrong, but a court gets involved in trying to help a person in need access community-based services. It's not a new program, it's a new pathway to access existing programs. So we did not create a new program. Legislature did not call for creation of a new program, but legislature called for a better access and for creating a way for people who do not very well fit into our voluntary treatment model to kind of help and push them and assist them through the court process in engaging with existing treatment resources. The goal is to prevent institutionalization, conservatorships, incarcerations, and it's really focused on individuals with untreated schizophrenia, which can be untreated often due to lack of insight into the problem. So the individual doesn't really recognize, doesn't have the insight that they need help. And other psychotic disorders. And we'll talk a little bit more about the eligibility criteria as we move along. This presentation is actually available on our website. I have the website right here in blue highlight, and I'll show you as we go along how to navigate it. So all the slides are available there, and the links in the slides are live. So the information and resources for petitioners and from California Health and Human Services and from our courts, California courts, is all available to you at just one click when you access the presentation. We're going to start accepting referrals on December 2, actually. We have said December 1, but that's Sunday. So you can send in referrals anytime, but they are going to be processed on starting December 2. So who is eligible for CARE Act. To be eligible, an individual needs to be an adult, so 18 years old or older, and to have a schizophrenia or a psychotic type disorder. And really who we are trying to reach through this legislation is those difficult to reach individuals, difficult to engage individuals who are experiencing mental illness that is so severe in degree that is affecting their functioning in a way that basically puts them at risk for grave disability and for institutionalization starting with the 5150. So we're trying to help them avoid that and to get engaged in services before they reach that level. So hence, as somebody who is not currently clinically stabilized in an ongoing voluntary treatment program, what it means is that somebody may be in treatment, may be enrolled in treatment, but they really don't engage enough, and that is not working well for them, and they continue deteriorating. But in this case, I would expect that a treatment provider will support a petition to either CARE or AOT and will work with a family member and with the individual on helping them get the help that they need, even if it means engaging the court process. It's really important that individuals whom we refer or petition for CARE court, that they are unlikely to survive safely in the community, and that this is the least restrictive measure for them. So we want to see some efforts of engagement. We want to see some attempts to engage them from a behavioral health provider. We want to provide them with an opportunity to avoid court process and engage in treatment. And only if there is enough evidence that that did not work for them in the past and is not likely to work for them now, we would support a CARE petition. There are some exclusion diagnoses, the exclusion criteria, and these include mood disorders, for example. So really, it's only the psychotic disorder class that qualifies somebody. Somebody who has a mood disorder like bipolar disorder, major depression, or post-traumatic stress disorder would not automatically qualify for CARE Act. A question has been asked, and what if there is a mood disorder with psychotic features? I don't know how to answer this question in the moment. We will kind of have to see how it plays out in the court. It really depends on the clinical opinion presented by a licensed clinician in the court and whether the court will accept it or not. But in general, mood disorders exclude somebody from being considered for CARE Act. Psychotic disorders due to medical conditions, such as traumatic brain injury, autism, dementia, and other neurological conditions are also excluded from CARE Act. And substance use disorder that does not otherwise meet the definition of a psychotic disorder. So if somebody experiences psychosis while they're under influence, that would not qualify them for CARE Act. I wanted to stress that even though this is a court process and it is a civil court proceedings, there is still a lot of voluntary element in this process. So we consider it a voluntary treatment. In our county, involuntary treatment usually will be in an inpatient setting, in an institutionalized setting. So on the left hand, you see CARE court and AOT, assisted outpatient treatment, that has some overlapping criteria. These are the two civil court processes that behavioral health services are engaged with and support and provide services for. And we still consider them voluntary, even though there might be a court order involved. For the involuntary, we're talking about basically involuntary holds and conservatorships. And this is what's coming, some changes coming with the SB 43, which I'm sure that a lot of you are following, when the grave disability definition might change. So that is considered involuntary, and only in inpatient setting can we administer medication forcefully or involuntarily. And that's really important distinction. And we'll talk a little bit more about it as we go along, but I just wanted to make sure that we're all aware of these distinctions and of how much voluntary component still exists in care court process. So who can be a petitioner? An adult person who's a family member, might be a roommate, might be, has a really good knowledge of the individual because they are living together, sharing a living arrangement, a behavioral health provider, first responder with a history of engagement with the individual. So it cannot be a police officer just the first time saw the individual, but somebody who has been exposed to multiple incidents with the same individual and really knows the situation well. They can petition. And also the respondent themselves. And what it means is usually what we see in the counties that already implemented CARE Act as cohort 1, that respondent themselves petition. It's an individual who is incarcerated and they're petitioning with the help of their public defender. So the public defender basically submits and files the petition with the court, but it is considered to be as if a respondent themselves are petitioning. Because really, if anybody themselves are able to go through this complex petition process and they're so well organized, they probably don't qualify for, they probably don't meet other CARE Act eligibility criteria, because that's a pretty intense process. So how to access? How do you, if you have somebody you're concerned about, if you have somebody that you've really tried to help them get into treatment and it just nothing worked, how to access care court? We have two ways. In our county, the unique feature that we have is what we call care outreach. This is on the left hand in the on the blue section. This is when we accept the so-called soft referral. You may want to get a consult. You may want to get engaged with the team, and start working with the team that understands care, that understands civil commitment process, but you are not ready yet, or you just feel like maybe it's too much of a burden to go and file a petition with the court. So this allows the opportunity for Behavioral Health Services Department, BHSD stands for Behavioral Health Services Department, to engage prior to filing a petition. And you can contact the care outreach and engagement team by calling the call center, the 1-800 number, but you do not need to talk to the call center representative. You need to select option number 3. If you would call this number now and select option number 3, it would take you to the AOT team. By the time that we go live with Care Court, this option number 3 will have a sub-menu and will lead you to either AOT team member or a care outreach team member. You can also email us at careoutreach@hhs.scc.gov.org. We already are receiving emails into this inbox with questions, with requests to come and do a presentation. This inbox is live and is being monitored by our team. And you can find the care outreach referral in our website. And I think it's a good opportunity actually to show you the website. So I just clicked on the link and it opened up our website. Let me drop it into.
It's actually not sharing the other link. It just still continues to share the, oh, now it has a pop-up. So
Yeah, I know it. Well, I was trying to move it. I was trying to grab it and it just didn't. Thank you, Romina. Thanks for monitoring this. So, so the link actually led to this. I didn't have it pre-opened. The link is live. And it's BHSD Santa Clara County. Really, if you just type it into the search engine, it will take you to the Santa Clara County BHSD, and we have a Community Assistance Recovery and Empowerment Care Act page over there. And in this page, there is a lot of helpful information. So you can access a brochure, you can access the referral form in here, and also care presentation. This is the slides that I'm presenting today. For the referral form, it's a fillable PDF form, But please always remember to save it first into your device, because this is not the type of form that you can fill and submit online. This is the type of form where you have to save, then you fill it out, and then you can email it to us. We're not that high tech. We were not able to create a form that just feeds into a database. So please remember to save it, because otherwise information is not going to be saved. And you can also call the call center, option number 3, and talk to the staff member and have their assistance in completing this form. It's a 2-page form, some basic information about who is completing the referral, who is the respondent, that's the individual you are referring, and then a bit of a history of what's going on in the last 2 or 3 years, incarcerations, hospitalizations, acts of violence, threats, and immediate risks and safety concerns. Why do you think that they are unsafe in the community? And some history of non-compliance with treatment. As much information as we get, the easier it will be for us to substantiate a petition. So this is how you reach care outreach. You also have the option to simply go to the court and file a care petition directly with the court. And I always say that if you're frustrated with BHSD, or if you've tried treatment for your loved one with us already and it didn't work, and maybe you didn't have a positive experience, you don't have to go through us again. You will have to interact with us, because still the services are provided by our department. But you can go straight to the court. There is a self-help center at the court, and file a petition without asking for our help at all. So we have the address here for you in the slides, and there is also a link for electronic to how to file electronically. The petition documentation is a little bit more extensive than our referral form, and we cannot help in this case to file a petition and to get all the documents ready, but we will get engaged when we get a court order to investigate, and we can support the eligibility of the respondent and still be helpful to you and work with you, even if you decide to submit a petition without us. Okay. So what happens if you do reach out to the care outreach and engagement team? We receive the referral and we immediately start attempting to engage the referred individual in services. And if they are somewhat willing and maybe the team, did their magic and engaged, we conduct warm handoff to appropriate services, and we can actually help avoid care petition. It is always an option for you and for your loved one. But in case you value the voluntary engagement without court involvement, we can help avoid that. We really have a very strong team that is good in engaging quite resistant and quite low insight, individuals with low insight who do not understand that they need help. And we do succeed to engage them in treatment. If no success, then a qualified petitioner or us, which we are also a qualified petitioner, will proceed with the care petition as needed. We will not just drop the case. We will help through the care process. If the care petition is filed and BHSD receives care court order to investigate, there are 2 outcomes. One is that we successfully contact the individual, and one is that we are unable to locate the individual. So in the case that we successfully contact the petitioned individual, we have about 14 days to investigate, provide the report to the court, and try to engage them in treatment, which is a very short period of time. And we know with this population that sometimes that's not enough. That's why we really are advertising our care outreach process, because we think that it can help to get more individuals into treatment in a less adversarial manner. So we can still help avoid the care case if the individual engages in treatment during this investigation stage. If the individual is unwilling to engage in treatment, we submit a report accordingly, and CARE Act case commences and proceeds through the court. If we are unable to find the individual, we try multiple times in various ways. We engage other outreach teams. We usually try quite for a long time. But again, we only have here 14 days. So we will have to submit a report to the court based on records review within the 14 days. And the court will have to rule whether to proceed or not with care plan development while the individual is not present. Through the care court process, the individual has many rights. They have the right to legal counsel. They have the right to actively participate in care process and in care plan development. And they have a right to have a voluntary supporter appointed by the court and selected by the individual as if desired. So not appointed by the court is an important point, right? You can be asked and selected by the individual to be a voluntary supporter, but the court, for whatever reason, might deem that this is not helpful, and and ask that person to not be a supporter. However, the likelihood is you are going to be appointed and you're going to be approved, because the court really values that the petitioned individuals have support by the people whom they trust throughout this process. The supporter role is to help the participant to understand what's happening and to help them communicate their decisions and their wants and to express their preferences. So it's basically to support the participant through a self-directed decision-making process. And there are some trainings that you can access on this. There are online trainings about supported decision-making and about how to be as neutral as possible in the court process and how to best support your loved one through that. A supporter can be, again, an adult, so a family member, a friend, a faith leader, you know, any person in a mentorship role. And it really helps if it's a person with lived experience, if a behavioral health provider is being asked to represent and to be a supporter. But if an individual trusts somebody from the past experiences and they want a service provider to be their voluntary supporter, that's a possibility as well. So petition has been filed, behavioral health services investigated, submitted the report to the court deemed that the individual meets criteria, and now we're proceeding to develop a care plan. That's basically the culmination of this process. The care plan is developed in partnership. That's why we're saying, you know, nobody did anything wrong to be taken to court here. It's a civil court process. The individual comes to participate in this care planning in partnership with the clinical services team, with their legal counsel, and with their voluntary supporter. And that plan may include behavioral health treatment, stabilization medication, and housing plan. The State Department of Health Services is actually calling this the three-legged stool. And there was a whole discussion in the recent conference, you know, why three-legged stool and why not four-legged stool? And I don't remember like what the conclusion was, but in my mind, the three legs are enough to have a stable stool. If you sit down on a three-legged stool, you're going to be sitting sturdy. So these are the main things really that we're offering in very, very general strokes. So the behavioral health treatment, the medication, and the housing. And then the court order is basically when the court reviews the care plan and adopts it. So approves it and adopts it, and it becomes a court order. And both the participant and us, the Behavioral Health Services Department, can be a party to the court order for up to 12 months. So in a way, with the care court process, a person can take us to court because a judge can say, you know, can mandate the behavioral health services provider to provide the services that are in the care plan. It's not like we don't hold our providers accountable now without the court process, but it's even stronger when the judge mandates the provider to provide these services. So this is another way of to sell the process maybe to your loved one, in case they are apprehensive about going to court. I know some counties said that they kind of even said while outreaching, they even said to their respondents, like, yeah, go take us to court. You go and express your wishes. You go and tell the court what it is that you want, that you need. So once the care plan is developed, it could be care plan or care agreement. I'm not going to go into detail, but at some point in the, in the process, the individual could actually agree to the care plan, and therefore it becomes a care agreement under the supervision of the court. It does not become a court order, but the process is the same. So with that, when there is a care plan and a court order, the petitioned individual can engage in treatment, or they can still not engage in treatment. That is also a possibility, because remember, these are individuals who were very difficult to engage from the first place. And just because there is a court order doesn't mean that that changed. So what happens when the person engages in treatment? How does it look like? Well, we provide all the services that are in the care plan. We conduct regular status hearings with the court, and the program continues for 12 months. The participation in services continues for 12 months, and the court hearings, with the opportunity to extend if appropriate and if needed. So the court will consider at the end whether this is a graduation, or do we continue monitoring and implementing the care plan under court supervision? If the petitioned individual does not engage in treatment, we continue outreaching and engaging. We continue those attempts. And we already have quite a lot of experience in AOT doing so and having success. And we know that sometimes, it takes longer time with some people to get their buy-in. So we have teams who are very committed to just continue engaging. This is kind of, well, I don't know, funny story, but we actually had a grievance filed against one of the AOT team members for coming too often and too much. And the individual said, this person is harassing me. So, I mean, of course, that is not a desirable outcome. We do not want somebody to feel harassed by us, but just to sort of make a stronger point here about how persistent our teams are in attempting to engage somebody in services. We continue conducting regular status hearings with the court and getting everybody together, the public defender, the county council, the treatment provider, the judge, and hopefully the individual that is a respondent, and trying to get to a place where they will feel like they can engage. If none works, then alternative referrals are considered. One of the options is assisted outpatient treatment, which is a similar type of process. However, what we see is that sometimes changing a team, a provider, a treatment team can do the trick. Maybe something didn't click with the other team, and if they try with the AOT, it will work out. And failure to engage in care plan may be considered in LPS conservatorship proceedings. Now, I want to be very careful about this point because I know that the community was quite excited about CARE Act being a pathway into conservatorship possibly. And what we see in the legislation and in the implementation so far, that nothing could be farther from the truth. It's really not opening up a pathway into conservatorship. The intent of the act is to actually prevent conservatorships as much as possible. The failure to engage can be considered in LPS conservatorship proceedings is a very general statement. There's also a qualifier there that that failure must have occurred within the 6 months of the LPS proceeding. So it can be considered, but there's no further guidance that legislature provides how it should be considered. So I just don't want anybody to erroneously think that we're opening up a new pathway into conservatorship. It's very much in the infancy right now, and we're just gonna see how it plays out. We know that it didn't work like that in other counties, and that it was not really written like that by the legislature. So a quick summary and review of what, when the care plan is approved by the court, what services are provided. So under behavioral health treatment, we include mental health, substance use treatment, we include medication and other supports for wellness and recovery. Under the housing plan, all of the housing services and supports that are available to our other intensive outpatient treatment program clients are available to care participants, will be available to care participants. So boarding care placements, which is licensed homes, shared independent living arrangements and rent assistance, which is what sometimes is called unlicensed boarding home. Emergency housing and other housing needs. So there can be funds, to help somebody find a temporary shelter while we're working on a longer term housing arrangement. And coordination of services. BHSD coordinates all the services listed in care plan. We are responsible to make sure that this is happening. And we will coordinate the follow-up referrals to services when the care plan is completed. A word about medication, because I know this is a really painful point sometimes for a lot of people, and we get referrals also into our other program, the AOT program, when people think that we will be able to somehow get the medication forcefully administered in an outpatient setting. So I recently saw a slide by a person from the State Department of Health and Care Services, and it was a very nicely sort of explained, so I tried to replicate it here. So we have the forced medication, right? Medication can be forced, and that can happen, which means that it's being administered without individual providing a consent or actually even actively resisting. So it can only be done in an inpatient setting. It is considered to be unsafe in any other setting than inpatient. And then on the other side of this range is in the green is your voluntary medication, is when it is provided to the individual with full informed consent, when they understand what they're taking, when they understand what they're agreeing to, the risks and benefits of it, and whatnot. And that is what usually we do in outpatient level of care. None of our psychiatrists will be able to prescribe medication without that type of informed consent, which makes it completely voluntary. Now, Care Act legislation put the individuals who are care court respondents in this gray area in the middle, which is basically providing a clinical opportunity enabled by a court order. What it means is that our providers, service providers, can now offer medication. If an individual is a care court respondent, we can offer medication without having that explicit, full informed consent and without having the signature on for that. So this is still not a forced medication because we cannot forcefully administer, but we are now allowed to include it in a court order and use that as a leverage to help the individual take it even without having their informed consent and their signature. Why this is important? Well, as many of you probably know and struggle with is that individuals with untreated schizophrenia, they have what's called anosognosia or lack of insight, and therefore convincing them that they need a medication is very difficult. And that is so common among schizophrenia spectrum disorders, that individuals suffering from schizophrenia spectrum disorders, that we end up really basically not treating it. So this puts us into this gray area where we can offer treatment even if we don't have an explicit informed consent. So that's, I think, what's revolutionary and what's new about CARE Act, because we didn't even have that in the AOT implementation. At least in our county, the public defenders would never allow the medication to be part of the AOT order. So I hope that explains it. I know for me, it was actually quite revealing to see this explanation. We're not going to go step by step. This is just our process for you to sort of know, and you can find it on our website. And really what I want to emphasize is that we created the step 0, that optional step 0 for the soft referrals for you to work with us when we already start applying the care court processes, when we already start sort of our soft investigation into the care court criteria to see whether this individual would be a good fit for this, would meet the eligibility criteria, as long as we're trying to engage them voluntarily. And always, if it doesn't work, we will always help you petition and go back to this, not backwards, move forward with the step 1 and go and file a petition with the court. And then we will just follow the court process and support you through that. So how does the completion of the care plan or the care court looks like? Really, it's just a graduation from the court. We continue services as needed and as appropriate. We don't expect that individuals stop getting services when they graduate from care court. Graduation from care court basically means that the individual reached this level of insight and stability that they're able to now continue engaging and enjoying the treatment services and getting the benefits of these services without the court support. So we will continue coordinating all the services. We will continue providing housing in the community and supporting their long-term recovery. We don't want any of that work to get destabilized. And the participant will be encouraged and may elect to execute a psychiatric advance directive, which basically allows them to document their preferences for what they want to happen in case they encounter another period of destabilization or mental health crisis. Really quick review. This is actually the last content slide on how CARE Act and AOT, which is assisted outpatient treatment, differ. So first of all, there are diagnostic differences, right? We talked about that. AOT is a serious mental illness. In CARE Act, it has to be a schizophrenia schizophrenia spectrum or psychotic type disorder. But in the care process, in the court process, that is different too. In the CARE Act, the process begins with filing a care petition. Right, everything before that is informal. The care petition filing is needed in order to start the care court process. In AOT, it's actually an AOT referral, and it goes to Behavioral Health Services Department. It doesn't go straight to the court. The petition to the court is a measure of last resort for AOT. In CARE, petitioner can be us, Behavioral Health Services, or other qualified petitioner. In AOT, it has to be us. It has to be BHSD. And in CARE, the petitioned individual is subject to the court order, and us, Behavioral Health Services, may also be subject to the court order, while in AOT, only the petitioned individual is subject to the court order. So these are the differences, because I know that to some of you, it's probably sounded very similar, these two processes. This is just all the things that we did since we started considering the implementation. We're now towards the end and doing our community education and information sessions and training our providers and really getting, ready to launch in a very short time. I think it took me a little bit longer, Ravina, than I promised, but I hope we still have time for questions.
Of course, of course. Thank you so much, Egle. I think we'll move to the questions. Okay, so I'm going to go with the Q&A section, and then I'm going to move to the chat section. I know a lot of people have put in questions here. Will a public defender be appointed as legal counsel If the person is unable to pay, if so, how are these people being trained in disability rights to ensure autonomy and self-determination?
So a public defender is going to be appointed, and we are working with the lead assigned for this, and also the same lead in the public defender's office is the one working with our assisted outpatient treatment program and assisted outpatient treatment court. Public defender, their role, they always tell us actually that their role is to represent the client's wishes, wants and wishes. It's not about their best interests. It's not about getting them into treatment. It's about representing what they want. On the other hand, we have a great relationship with our public defender, and we know that they can be very strong partners in helping to advocate and motivate their clients to engage in treatment. So they are ardent supporters of clients' rights. They are actually the ones who will sometimes slow down this civil court process because they feel that maybe some of their clients' rights are being taken away. So from my perspective, I know, that I've never seen that a public defender would not observe clients' rights. It's just the opposite. They're advocating for it, and they're training us.
Okay, thanks. Moving to the next question, how many clinical service teams will be in place and how many clients will each team have? The programs are all impacted.
So remember, this is not a program, right? This is just a pathway into existing programs. So we've identified one team, a multidisciplinary team, that will begin taking those initial referrals, and we're going to pilot the process with them. However, depending on the client's needs, they can be referred to any clinical team that is appropriate for their level of need. So we're not going to limit it. We're piloting it with one team. And depending on how many petitions are filed, we will take it from there and we will expand. But you're right, programs are impacted and new resources have not been created for this. The budget has not been allocated for creation of new programs. So we've identified a provider, a team that is is still ramping up their capacity. So we know that once we launch, we will definitely have capacity there. Also, we under law are obligated to prioritize care clients into treatment. So to some, I mean, it's not ideal, but because maybe somebody else gets to wait longer, but care court will get prioritized because the law tells us to.
Got it. Thank you. What happens if the participant is not compliant and self-medicating with alcohol and drugs?
This is very often occurrence. Comorbidities and co-occurring mental health and substance use disorders are common, and we trained our teams to work with that. We actually utilized quite a lot our substance use treatment services system, and we refer as needed and support individuals entering the residential treatment, substance use treatment, and getting stabilized with that before we do anything else. So all of that happens with the support of the assigned treatment team. So they're not there in the vacuum. The assigned treatment team that is a multidisciplinary team is already working with the individual, but we can help them also get the specialty help that they need for substance use treatment.
Okay, gotcha. Can government agencies submit applications?
Depends on, so social services can, but it's not the agency that's submitting the application. It basically would be the case manager, the social worker. It needs to be a person that has knowledge of the individual's condition. So you need to be able to provide some evidence of why this condition requires a petition. So yes, these can be employees of government agencies, but they have to have some sort of a relationship with this individual, which is usually a providing care or a supervisory relationship. It could be a probation officer, or it could be, you know, an adult protective services worker, but they all have some sort of monitoring and maybe even caring relationship with that individual.
Can someone from ConRep attend the care court, or is it too late to petition?
Can someone from, I'm sorry, where?
It says ConRep.
Not sure I understand. Maybe I'm mishearing it.
So it's in the Q&A section.
Yeah, I'm gonna try and maybe I'll stop sharing the screen so I can actually have a better access to Q&A. Q&A. I don't know what's ConRep. I'm sorry, that's an abbreviation. I'm not daring to guess what it means. Can we unmute Louis and he can ask the question?
Yeah, let me find Louis here. Louis, you've been unmuted.
Is it conditional release program? It's for it's for mental illness, like a program, conditional release.
What program? I'm kind of
It's
breaking up.
Conrep. It's conditional release. It's a mental health service program.
Mental health service program. Okay, so yeah, a mental health services provider can submit a petition.
Because I've been charged for not good supervision and sanity. So I'm in a mental health service program here in San Jose, and I was
So
wondering,
you're a client in a program?
Yes.
Okay. So, and you were thinking of petitioning for yourself?
In court, trying to see if I can get in care for it.
So I would recommend to work with your public defender on this.
Okay.
They can help you to do that. So this is what it's called when a respondent petitions for themselves, on behalf of themselves. It's usually your public defender, your lawyer, that is helping you to do that.
Because I think it's too late because I already got convicted like in 2014. And I've been in the program.
I don't, well, it's not, it's the petitions, the process only opens in December. So if it's too late for your case, it might be too late, but it's not live yet. Care court is not live yet. It's gonna go live in December, on December 2nd, on that Monday.
Okay. Thank you.
Okay.
Thank you.
Thank you so much. Thank you, Louis.
Okay.
Okay. Let me go back to the Q&A. What if the client is an AOT? What do they do?
So if the client is an AOT, they are already accessing the same level of services that would be offered through care process. If the client is not engaging in AOT, if AOT is basically failing for them, then I would encourage to talk with the case manager or the treatment team and ask about care petition. Or you can go ahead and just submit the care petition yourself, but we will go and talk to the AOT provider. I actually oversee the AOT contracted services for the county. So we meet with providers every 2 weeks at a minimum. So I would definitely then reach out to them and discuss that with them if we get a referral like that. I would suggest then utilize our care outreach option. You don't have to rush with the petition, but you can get a consultation and kind of alert the care outreach team that maybe AOT is not working out for your person.
I think somebody wants to just ask the question themselves. Carla, I'm going to unmute you. Just give me 1 second. Carla, I'm looking for you. Okay, here you go.
Yes. Hello?
Hi.
Hi, good evening, ladies. How you guys doing?
Good.
I want to tell you, thank you guys for your time. I have a question or maybe a concern. I have a daughter who's 31 years old today, and she's been homeless for 11 years. She's been diagnosed with schizophrenia, and she's in and out of the hospitals treatment. and I know that the medication, it takes 3 months for it to kick in. They know that she puts herself in danger in the streets. I want to know why do they discharge sometimes our kids or the patients when they know they still need a treatment?
There are so many things that are going into those decisions, and I think it's really tough when somebody doesn't meet the criteria to be in the hospital in inpatient level of care, but also they are really not successful in outpatient level of care. And it's kind of like they're in between. Their needs are sort of falling between these two major systems of care. And I think that that's what the AOT and the CARE Act are trying to bridge that gap. I don't know how successfully yet, but we're trying. So you can always, this is where the empowerment piece comes, is that CARE Act allows you then to petition through the care court, even if the hospital is moving with discharge and is not providing a good follow-up care for your loved one.
Okay, is there anyone I could talk to afterwards that could explain this to me more, please? Because I'm a frustrated mother. It's my only daughter. I get frustrated, different emotions. I'm trying just to help my kid.
So the best way to do this is to call our outreach team.
Okay.
And right now, our AOT services are live. So if you call the number and select option 3, one of our staff will answer the phone and they can walk you through and the process and help you figure out what's the best way to help your daughter. They're doing this every day, so they're the best people to have this discussion with you. So I really encourage you to call them.
Okay, ma'am. Thank you so much. You guys have a good night. Thank you for everything.
All right. Thank you, Carla.
I'm going to move to the chat section because I do see a lot of activity out there as well. One of the questions was, what are the long-term benefits or expected outcomes?
In general, the state expects us to, reduce the number of hospitalizations and incarcerations of individuals under that are petitioned. More specifically, what we expect is of course is stabilization, right? Because that's how we're going to see reduction in those major outcomes, is to stabilize somebody, their suffering is less, and to make sure that they are housed in a more stable way as well. I mean, I know from AOT experience that we cannot promise that everybody is going to be stably housed, and sometimes it's not because of the for us not trying, but it takes time for people to get back to kind of get socialized into certain living environments and succeed in those environments. And it takes several tries and it takes time. So there is some moves, but what we're expecting to see is some stability in housing, beginning to take medication, understanding that you need them, and a stability in symptoms that allow the person to function better in daily life. So for example, if somebody needed a lot of help with this activities of daily living, we would expect that the number of activities that they need help with is going down. And these are the things that we're monitoring.
Okay, let's see, a lot of questions. Let me move to the other ones. Nora, I see your question. Do you want to ask the question in, over audio? Because I do see it's a very long question, so I can allow you to speak if you would like to accept that. Otherwise, I can read it out.
Oh, either one. Let's see if I can find the what I put in there.
Okay. I see one question, Nora, that you're basically asking is somebody with anosognosia, what happens if they had services and then they graduate from them and stop accessing?
Yeah, I have put several questions in, so that's one of them. Yes. Well, we currently have a daughter who she was hospitalized last year. She's 30. She was diagnosed with bipolar back in when she was 19. But we do know last year she was hospitalized for about 6 weeks and spent 2 weeks in a place called Villa Fairmont Mental Health Services, which I heard was something for a long-term conservatorship. But the family took over. We provided a place for her to be, because we were told she only had up to 90 days in a certain place. So she spiraled. She decided when she was in the hospital that the doctors and the staff were trying to kill her, and they were paid actors, and that the medication is supposed to kill her. So when she was released, she didn't take it. She just takes vitamins, and she spiraled out of control. She was looking for a job, then she stopped. She didn't see anyone, was isolated in her house. And then she got into another psychosis about 6 weeks ago. So she was hospitalized for 6 weeks. Last week, she was transferred by Kaiser to a crisis residential program. And so we're wondering what would be better for her. She now has the diagnosis of both schizoaffective and the bipolar.
Mhm, mhm.
I'm wondering, how would the program at Kaiser differ from if she qualified for the CARE program?
So really care if she's in the program at Kaiser and she's staying there, I'd say it's really important to support her continue with that program, because what CARE does is to reinforce individuals engaging in existing services, right? So she's already in a service that may be working well for her right now. So the only thing that the CARE court adds to this is that it basically puts a court order in, and some individuals respond to that better. They're like, oh, okay, I better not leave, I better stay where I'm at. I better take my medication because, the judge is telling me to do so. I don't know if that would be the case, in with your family member. It's tough to answer specific questions without knowing more and without going into too revealing discussions. But,
Yeah.
I think the good news, what I'm hearing is that she is now in a program. So that means she's staying, right? Because she's not being held there by against her will. So that is good news. And if that at some point doesn't work out, then you can always reach out to us, and then we can start that process and do it with a civil court order.
When somebody files a petition, say we file, she doesn't want to communicate with us, but we know she needs our help because all of the friends and other relatives are not there for her anymore. But would she find out who filed the petition? Because if she knows that it's from us, she may reject the offer of the program.
So in AOT, we actually always ask. We give that option. You can tell the team that you don't want her to know that you're the ones making a referral or you're the ones filing the petition. In CARE, I actually think it's harder to do. Is if it's a referral, we can keep that information from her. We don't have to tell her who made the referral. But if you move forward with the petition in the initial hearing, I think that she would be privy to the information of who is the petitioner. So maybe in your case, then, it actually would be very beneficial to do a CARE referral first and have us petition so that you can stay as a supportive person and not get involved into adversarial process that she might. I mean, the court process is not adversarial. It's actually a very supportive, but that she might perceive it as adversarial if you petition her. So you can use us for that.
And then my other question was about when someone graduates from the program, is there any follow-up to make sure they're doing okay? Because
Oh yeah. So first of all, they graduate from the court, but they don't graduate from the program. We don't do graduation from behavioral health services. This is a lifelong support,
Yes.
sometimes that's needed for people. So no, we would keep following up. And actually the state is also on our case. The State Department of Healthcare Services requires us to report back 12 months after the graduation about people who graduated. So we're on the hook What, we believe it's our mission to do that, but we're also mandated by the state to do so.
Okay, thank you very much. I appreciate
Thank you,
it.
Nora. Okay. We have more questions. How long can you stay, Agli?
I can stay a little longer, I'm not,
Great, so we can answer all the questions then.
yeah,
Perfect.
yeah.
I see one here. Can someone on mental health probation after being released from an out-of-state hospital, which is Colorado, who's originally from San Jose, benefit from care team services to continue their retirement? And can a plan be developed before they are released from the Colorado hospital?
Oh, this is a very complex situation. So it wouldn't be a care plan under court order that would be developed before the release from Colorado. And part of it is because all the benefits, everything need to be transferred to our state, to our county. The person has to be, in order to be a care court respondent, the person has to be either a resident or needs to be found in the county of where the court is located. So this is something written in the law. With that said, though, we had out-of-state referrals into AOT of people who were transitioning back to their home state or home county, or were moving closer to the family. And we worked on a plan, which is not a court supervised plan. So this is just us working with the referring agency and with the family and with the individual and developing a plan and helping them move back here. So yeah, we can assist, but it wouldn't be a care court case from the get-go. We could petition the care court once the individual establishes residency here, but we would not be able to do that when they're out of state.
Got it. I do see some questions in the Q&A section that might not be relevant. So I was just wondering if you want to just take a glance at them and just
Okay, I was in the chat now, so let's go back.
because
to
I'm getting a little overwhelmed with so many questions
I
here.
know.
I also see somebody's hand being raised, so we can address that after this.
Does the OT program refer to substance use treatment? Yes, we do, and we coordinate treatment. How does care court differ from the drug and mental health court treatment program? From Department 6061. Well, so care court is not a criminal court. The collaborative courts, the mental health court, what's known as Department 60, 61, and 62, these are courts that are handling criminal matters. There's a criminal case against the individual. In the care court, that's why I keep saying nobody did anything wrong. The individual did not do anything wrong. They just are not engaging in treatment, and the court wants to assist them to engage in treatment. It's a civil matter. It's not a criminal matter. That's the main difference. Okay, so hopefully that clarifies. How about ACT? ACT is, not sure what this question means, but ACT is assertive community treatment, and it's a service delivery model, and that is the model that we're utilizing for our care respondents. We'll utilize for care respondents, and that's the model that we're utilizing in AOT. So hopefully that answered the question. Would it make more sense to expand treatment programs? Yes, it would make more sense, but we don't have budget for it. So it's a great question. And yes, it would make so much more sense to expand the programs. However, I'm pretty sure that when the governor was launching this bill, that there was some needs assessment across the state done, and there was a sense that existing programs can absorb the petitions, because we don't expect many petitions. I mean, we are okay with many referrals and helping with those, but petitions that meet criteria, judging by other counties, the numbers are not that high. So if the existing programs cannot accommodate the number of petitions, and if other, clients are getting to stay on the longer waiting lists because of care implementation, then I'm sure we will have to work with our Board of Supervisors on increasing our budgets and expanding programs, but we did not receive that this year. Can I have information to contact to care outreach team? Yes, if you go to our website, oh my gosh, I should have posted the website link in the, let me just do that, Rowena.
Yeah.
Wow. Okay, here we go. So, wait, do I have access to post in the chat? For some
Yeah,
reason,
you can do it.
where I
And then
see
you can
answer.
select
Oh, I can
everyone.
answer live, but okay,
And then you can select everyone because it gives you a drop-down menu if it's only to the host and panelists or everyone.
right, but I lost my question, so I don't know which question I'm answering now.
Oh, they wanted the contact information.
I know, but I don't know how to which comment do I attach the answer, because I don't have other options how to answer it.
I can type it. If you can just send it to me in the chat.
Okay, this is gonna sound like us troubleshooting technical difficulties. All I see in the chat is how many are answered, how many are open, how many are
Yeah, it's under answered and it's on the last one.
under answered.
Yeah.
Okay.
You scroll down and it's the last one.
There we go. And then if you can grab that and post it for all, that
Yeah, I'll do that. Yeah.
that would be so good. Okay.
I think
So
somebody
what?
already posted it.
Okay. Yes. Thank you. I'm sorry for
Thank you so much.
not being competent in managing the chat function on Zoom.
No. There's a lot of messages here.
It's interesting. We utilize Teams platform in the county, and Zoom is a little bit different, and sometimes minor differences can trip you up. So what Rowena is going to repost is the website for behavioral health services on CARE Act implementation. This is where you will find information how to access the CARE outreach team.
Okay, done.
Yeah, I see it posted. There we go. All right. Okay. So where do you want me to be now, Rowena?
I think we do have one person who's raised their hand, so let me just allow them to speak.
Okay.
To meet yourself.
Hi, thank you for the good information. My question may not be relevant to the CARE Act, but I have a question about my loved one. He's in Department 61 with AOT program. He has anosognosia, so well, instead of taking medications, he took off the antipsychotics. Actually, per doctor let him stop it, and now he's taking lithium, but it didn't work out. He had a manic episode, and now he's self-medicating with alcohol and marijuana. What steps do I need to take?
So I wouldn't recommend necessarily to go and petition for care court, because you already have him with AOT. The extra step with AOT, I know we start everybody on as a voluntary client in AOT. So if there was no petition submitted to the AOT court yet, that can be a step that you should be discussing with his case manager or the team who about petitioning him to the AOT court, because it's up to the team to decide that. Because the care court and AOT court criteria are quite overlapping. The processes differ a little bit, but he's already with the team. So I would encourage that you work with the team to help him get the care that he needs and give him a chance to succeed with this team.
So I need to talk with the case manager first and
Yeah.
discuss.
Yeah. Yeah.
Okay.
And of course, the case manager is going to ask if you have a release of information signed, you know, and they're going to, if there's no release of information authorization form signed, then they're going to ask the, is it you said your son? I'm sorry.
Yes.
Yeah.
Right.
Then they're going to ask your son to sign that. So don't get frustrated if they don't provide information right away and they don't start sharing information. This is out of respect for his rights. So it might take a little bit of time to establish that, but once they get the release of information from him, they will be able to share with you freely.
Okay. So if there's no ROI and yeah, of course they wouldn't give me the information about him, but can I just give information to the case
You can give
manager?
them, oh yeah, they can receive
Oh.
information. They just cannot
Okay.
share back.
Oh, I see.
Yeah.
And also I can ask the case manager about their plan in case if the client engage with the substances, and I can ask them if they can put him into like another program or something like that. Do you
So
know if AOT has also a substance use treatment program?
AOT doesn't have substance use treatment program, but AOT coordinates with substance use treatment programs.
I see.
So AOT can place in substance use treatment and coordinate with that program, but they don't run a substance use treatment program
I see.
themselves.
So then if the client doesn't want to be in the substance treatment program, then
no court order will help. No care court, no AOT court order will help, because in this country, well, in this state, I don't want to speak for the whole country, substance use treatment is completely voluntary. There's no, even if it's a Department 61, you know, court order, it is still voluntary, right? Because a person can choose.
Right.
They can choose. They can say, no, I'd rather serve my time than go into this program, right? This is the choice, the voluntary component. Nobody can force somebody and hold somebody involuntarily in substance use treatment program. There are very clear laws about that, and we simply cannot do that.
I see.
Yeah.
Thank you so much.
Thank you. Okay. Let's see if we have any other questions in the chats.
Right in the chat, I'm trying to figure out, okay, how could I get a copy of the materials presenting in this meeting? That is in that link. If you go to the website, the presentation is posted there. All of the slides are available to you with the exception of one that I added last night, and that's about the medication and how care court falls in the gray area. So that's the only slide that is not posted. Everything else is posted in our website. Have engaged with people, I would appear to have mental disorders. So we're able to have a conversation. I think it is often a defense mechanism for some people to, yeah, it could be. It could be, and that's why it is a court process where an individual has rights and where they have a public defender, and so that nobody would get court ordered into treatment if they really don't need it. There's a clinician presenting the clinical opinion. There has to be documentation of prior hospitalizations and the diagnoses and all of that good stuff. And there is a public defender also defending their client. So it's a courtroom like any other courtroom, except that there is no jail time, there's no conviction that follows. There is a treatment plan that follows. Yeah.
Nicola, do you want to take the last couple of questions?
Mhm. What role do service providers have in the process? So behavioral health services department supports the petition process and the going through the court process. Once the care plan is developed, that is when it's handed to the service provider. The service provider then is in charge on delivering the services. We will, of course, engage with the service provider in the care plan development so that they can have their input and they start working with the client in advance. But officially, their role starts when the court order is issued. I think some of them I already answered. How do advanced directives affect this process? They don't. This is just at the end of the process that we can sort of have an impact on how the next crisis will be handled. How is a psychotic disorder identified? So there's many questions in here. Who's qualified to make a referrals? I encourage you to look at that slide where I listed everybody who is a qualified referral source. How is psychotic disorder identified is by a diagnosis, official diagnosis from a licensed clinician, and it could be a licensed clinical social worker like myself, LCSW. It could be a licensed clinical psychologist. It could be a psychiatrist, but it has to be a licensed mental health clinician that provides that diagnosis. And let me see what else is in this question. What happens when there is a concern about a possible misdiagnosed disorders? Sleep deprivation or temporary psychosis. I think we have safeguards in the process to prevent that from, getting considered as a true psychotic disorder. I can't speak for other clinicians, but usually sleep deprivation and sleep disorders are considered as a rule-out diagnosis before reaching a diagnosis like schizophrenia. I'm pretty sure, if it's a temporary psychosis, that's where all those exclusion criteria that we talked about, temporary could be due to sleep deprivation, you're right, temporary could be due to substance use. There's usually some evidence that it's of a temporary nature, and then the individual is not eligible to go through the care court process. But of course, sometimes you go to a different psychiatrist, you get a slightly different diagnosis, right? It happens. So again, the individual has rights. A second opinion can be presented. The judge and the public defender will do their job, making sure that those type of errors are not happening. And if they do, the family member can be a voluntary supporter who also advocates for the individual and raises all these questions and raises all these possibilities in the courtroom. Okay, it's 8:25 and it's getting close to, I think, many people's bedtime.
Exactly. But thank you so much, Egle, and thank you for the presentation. Thank you for answering so many questions. I think I've never seen as many questions at a general meeting as much as I've seen today. It was like overwhelming between the chat and the Q&A section. So thank you for answering most of them. And we really appreciate you coming in tonight and doing this. So
thank you for having me. And if there's a need for follow-up and to answer more questions, invite me again.
Of course, absolutely. So thank you everyone for joining us tonight. And we won't be having a general meeting in December, but we'll see you in the new year in January of 2025. Thank you and